Hello friends, in the series on the income tax cases, today we will discuss a case which is based on imposing of penalty on the assessee under section 271 subsection 1 clause C. In the present case, the issue before the Honorable Himachal Pradesh High Court was that if the assessee makes a claim in his return of income, or if the assessee shows his income in a particular head and the assessing officer is not satisfied about the taxation of that income in that particular head and changes its head, which is also confirmed by the higher appellate authorities like CIT appeal, tribunal or the High Court. So whether in that case, just because the assessee has made a claim in one head of income while it should be another head of income, due to which the tax of the assessee is increasing. So just because on this basis, whether it can be said that the assessee has furnished inaccurate particulars of income or concealed his income, and can penalty be imposed in that case? This issue has been taken up by the Himachal Pradesh High Court in the case of Principal Commissioner of Income Tax versus Ankita Deposits and Advances Pvt Limited, and this case is reported in 483 ITR at page number 458, and the date of the judgment is 9th November 2023. In the present case, the assessment year involved is assessment year 2002-3. The assessee was having a lot of transactions in the sale of shares, and the assessee was holding the shares as investment also. And during the assessment proceedings, the assessing officer observed that the assessee has shown the shares as stock in trade up to the assessment year 1999 and 2000, but in the present assessment year, that is assessment year 2002-2003, the assessee has shown his income from the sale of the shares as capital gain. So the assessing officer was of the considered view that this income should be taxed under the head business income. Accordingly, the assessing officer, after causing the assessee, changed the head of the income, and there was some tax liability on the assessee, and this assessment order was confirmed by the higher appellate authorities like CIT appeal and tribunal. When the tribunal upheld the order of the assessing officer, the income tax department in a great enthusiasm caused the notice that the assessee has furnished inaccurate particulars of income, so the penalty should be levied on the assessee. The assessee pleaded that the assessee has not shown any incorrect facts in the return of income. The assessing officer has not found any fact which has been shown by the assessee as incorrect, and the assessee has disclosed all the facts regarding the sale of the shares in the income tax return. So it is not a case of furnishing inaccurate particulars or concealment of income, but the assessing officer levied the penalty, which was confirmed by the CIT appeal. And when the penalty proceedings or the appeal of the assessee for penalty was in the tribunal, the plea of the department was that since the quantum appeal has been confirmed by the High Court, so it is a fit case for imposing the penalty. For this, the tribunal observed that by going through the order of the High Court, that in the present case, when the High Court confirmed the demand, there was no comment by the High Court in the order of the High Court that whether the assessee has furnished any inaccurate particulars or there is concealment of income. So just because the High Court has confirmed the demand, the penalty cannot be levied, and the tribunal said that to expose the assessee to penalty, it is very essential that the assessee is covered under the provisions of that penalty provisions, because in section 271 subsection 1 clause C, the words are very clear that the penalty can be imposed only for the concealment of income or furnishing inaccurate particulars. The tribunal said that in any imagination, if the assessee has claimed any incorrect claim, it cannot be said that the assessee has furnished inaccurate particulars of income or furnished inaccurate particulars of income or has concealed his income. So the tribunal was of the view that In the present case, when the assessee has shown all his facts into the income tax return which are not found to be incorrect by the department, the penalty is not leviable, and the same has been confirmed by the High Court. So friends, from the reading of this case, it is very clear that just because the quantum demand is confirmed by the High Court or the assessee has made some incorrect claim in the return of income, so without proving that the assessee has furnished some inaccurate particulars, the penalty cannot be levied on the assessee. Thank you friends.